Dr. Prashant has written that when he visited Calcutta, he saw many things which was a new experience for him. Reviewing a contract has certain advantages. For example, helps us to ascertain whether contract is legally written and provides unambiguous terms, whether the language is precise and defines legal jargons, whether it complies with the law, whether parties to the contract understands all their duties and responsibilities clearly, whether any provision has been included which the parties did not intend to include, and lastly, whether any amendment or change is required or not. So far as the basic steps, these according to me could be the basic steps for the drafting a contract. And the basic purpose of an agreement is to avoid the future litigations. So and therefore, and to avoid that, the most important thing is the clarity. Everything should be ambiguous. And then if you are drafting a contract for one party, if you are there, then you must be conscious and you must have to look that the obligations of other party are clearly stated.
Start the video. So we just wait for a minute. If participants have some questions.
May I suggest one thing? We should go ahead with other speeches and then finally we will come to the questions.
Alright, sir. Okay, sir. Thank you so much, sir. Now, without any further delay, I would like to introduce our second panelist for today, Aditya Mishra. He is practicing at both the Council and the Appellate side of the Hon'ble Patna High Court. He is a guest lecturer at Surendranath College. Sir is a ex-assistant governor and deputy secretary at the Social Club of Calcutta. Sir is a retailer at the Hon'ble Electricals and MS French Motor Company. Sir will talk about the structure and the legal and the style of legal writing with respect to contract drafting. With this, I would request Advocate Mishra and Sir to take over.
Thank you, Umaira. A very good evening to all of you, and especially to my learned friend, Mr. Mishra, and my learned friend, that is Mr. Chandra. It's really my proud privilege and honor today to be invited. After such a long time, you are all going through a pandemic situation, and I literally thank the Literary Arts Club for taking all such initiatives, to hold this webinar so far as contract drafting is concerned. Now, my learned friend Mishra ji has already, I think, not only enlightened the students, I must appreciate, and I take this opportunity that you have also enlightened me in many ways. Thank you, sir. So far as what Mishra ji has done already, I think he has covered all the parts. Nothing remains for me and my other learned friend. But I will, of course, try something which I will share my experience in practicality in the course, which I normally do. All of you are aware of. When I normally teach, I never prepare myself. Touch wood. Everyone knows I always go unprepared and try to share my experience. This is what I'm known for. At the very outset, already Mishra Saab has, enlightened us with what drafting should be done and how it should be done and what are the ingredients which has to be there. Otherwise, there should be a problem. At the very outset, I would always, I have always told my students, I have told my juniors, the most important factor which is there in the life, see, when you have chosen a profession like law, I feel that morning shows the day. We are all accustomed with this proverb. The most important thing for a lawyer, I think, he should strengthen his command in the language of English. And I always told all of you that if you really want to be a good lawyer, you have to strengthen your language in English. And to do this, apart from law books, apart from attending this webinar, which is also very important in life, I've always recommended, even I do, I teach myself before I give speeches, that we should indulge in more reading. It can be a storybook, it can be an English movie, it can be newspapers from which you can gain a lot of knowledge. Right? So let us go to the topic today straight away. That is what already Mr. Mishra has enlightened us. How to draft a contract. What are the structures which we should know? Now before going to the drafting part, we should be at least knowing the Indian Contract Act, that is 1872. What does it speak of? I always believed in myself, becoming a lawyer before becoming a lawyer, that law is nothing but a logic. I think my Lalit friends will also agree with me. There is no bar, I tell you, that only, that a lawyer is supposed to draft a contract. There is no bar. Even an individual can draft a contract. And apart from that, if that individual feels that I'm strong in the command of the language of English, then that overconfidence, as Mr. Mishra has told, that will let you down. Different parts of the country was suffering, rather, they were not able to pay the fees because there were so many people who are now even getting their salary. So, right, they can approach the High Court. So, immediately you see, while adjudicating this matter, the High Court of Calcutta, even Patna High Court, even if they have come to a conclusion by directing the school, they also had to go through the fee structure, right? First, and the contract. So now you might, jump. What sort of contract was there? There was no contract. Yes, of course. I said there was a contract. The moment we are admitting our child to a school, you are applying through an application, if I'm not wrong, subject to correction. The moment you are applying through an application, now that has to be adjudicated by the principal and the head of the school. And once it is arrived at a situation where your child will be admitted, then the next step is that they give you a form which has to be filled up, asking for your details and asking for all the necessary things which is required for admission. So it is in a form of a writing. It is in a form of a writing, and it's not only a paperwork. So normally the school also contract between the child, the parents, and the school authorities. If I'm supposed to give something to the school, then why do we tell to the authorities that we are also expecting that the school will provide such things? The issue was very simple, Mr. Mishra, before the High Court, that during his pandemic, there is no classes. Everything was online. So the question of electricity consumption, which they were charging, the lunch fees, which they were charging, and the other transportation charges, which came vaguely before the High Court. I was proud enough to be one of the counsel in the matters before His Lordship, the Honorable Justice Sanjeev Banerjee. So the question of contract came there also. So ultimately the court felt that these are unreasonable things which they are asking. Now I will give one very good example. Now suppose I am a landlord of a premises today, and I am in a position of a flat, and one gentleman is looking for an accommodation. He comes to me and approaches me that I am in I require an accommodation, kindly give it to me. I say, listen, you have to give me rent and you have to execute an agreement. So he says, I'm ready and willing. That agreement which is executed, I categorically take these terms that you will be not provided with electricity and water. Are you ready to sign this agreement? This poor gentleman who is in search of accommodation, his first thing which he will think, let me get some food first, thereafter I will think of sleeping. So he says, okay, you don't have to give me anything, but I need that agreement. He signs the agreement, the agreement is executed, and thereafter, not even 24 hours, 16 hours, he feels the heat, and he is in requirement of water. Thereafter, he goes to the court, saying that this was the agreement. I can assure you, even my learned friends who are there, they will assure you, the court will call the landlord and say this agreement has no validity. It is not enforceable. Why? This is why I want to address. Why? You have to understand. Always there should be a why. Water and electricity are the basic necessities. Article 21 of the Constitution of India gives right to all the citizens, right to live. If you stop my water, if you stop my electricity, am I supposed to live in this world? So, the court will come to a conclusion, this is a vague agreement. This cannot be, accepted. It is not enforceable by law. It will be thrown away. Within 48 hours, I think the Patna High Court has the determination, jurisdiction of electricity. Maybe the judge will order that within 24 hours, I am directing this. Over here, it is CSC, I am not aware of. The electricity department to give electricity connection today. It is also entitled to get electricity. So now comes the drafting thing. See, it is very easy. I was telling you that an individual who is not a law practitioner can draft a contract because he has a good command in the language of English. But the problem what it is, there are a lot of advantages and disadvantages. Even Mishraji has told this very nicely. Why people should encourage rather themselves as well as others to go before an advocate who's sound, not only with the command in the language of English, but also in regard to the law. Why just to avoid future litigations. The moment you see there are disadvantages, why I tell you, because when you are approaching an advocate, a lot of huge expenses might incur. You might think of that because I have to pay Mr. Ahmed and Mr. Mishra and Mr. Chandra, so let us go to that, Shialda code. There is a typist who has all the formats of contracts and agreements. Without spending any amount, let us get that format and get it done. I can assure you, in 20 years of experience, in my High Court, I've seen so many litigations where the clients have come and they have literally, in a state of crying that what wrong we have done. Tell me one thing, today I don't know at this stage, because you're a law student, you must not be dealing or knowing so much about the bank agreement. But of course, my learned friends who are here, when the bank is executing a tripartite agreement in respect of a property which the purchaser is purchasing with the promoter, there are at least 800 pages, sometimes 600 pages which they ask you to sign. Why they are doing so? Because 2-3 parts which my learned senior friend Mr. Mishraji has, I think he has not taken this point. In the contract, he has spoken about force majeure, but he, subject to correction, should have also referred to arbitration clause. He should have also referred to indemnity clause. Today, commercially, mercantile, the commercial suits which are being filed, if you see the volume of an agreement, you will see that the bank nowadays, when they're giving loans, or if there is a home loan, they make sure that they are covering each and everything. Each and everything. Because today, if I'm taking a crore of rupees from a bank and I am mortgaging some of my property, it has to be nicely drafted also. It has to be seen why do we give, you have to ask, that why there is an arbitration clause. Today, if someone has violated the terms and conditions of an agreement and a contract, I say, what are we supposed to do? Are we supposed to take law in our hands? Are we supposed to, physically start assaulting that person? You will be betterly advised by a lawyer, or you must advise yourself, let us approach the court. And every one of us is aware of it. Even a student knows. You file a civil suit, there are so much of, this is the Indian Civil Procedure Code, and it takes a healthy lot of time. It might take 20 years to be disposed of. But the moment in a contract, nowadays you see in each and every contract, there is an arbitration clause. People are trying to, be smart. They want to avoid the long procedure of court. They don't want to fight for 20 years. If you have an arbitration clause, the suit court will say that you go before an arbitrator under section 11. What is the advantage of going to the arbitrator? Because it can be decided in 11 months. Now, after the award is passed, you have the right of appeal. You can come before the Hon'ble High Court in Calcutta, but not 20 years. Let me tell you this. Because arbitration proceedings are very fast. Very fast. I tell you. So, other parts which already, he has discussed so nicely and he has enlightened, we are all grateful to him. See, I have been always thinking of one thing, that to draft something, first you have to be educated with the basics. This is what I've told you all. If I want to be a cricket player, and I just think on a day that I will become Sachin Tendulkar, it cannot be. Today if I think, or Mr. Mishra or my friend Mr. Chandra thinks that we should get the same stature of Kapil Sibal or Ramjet Malan. Of course, it is not impossible. Let me tell you this. It is not impossible that all three of us cannot be like that. But it requires some time, and it requires huge investment of your time in reading. Unless or until we don't read, we are not educated much among, and we don't understand what the subject is. It will be very difficult for you to argue a case, or you can say to draft a contract, what the today's topic is. So my request to all of you, each and everything which you do in life, rather it is drafting of contract, whether you are making submissions before the trial court, or you are cross-examining any witness, or you are leading through chief examination, or you are arguing a matter in the High Court, or even Supreme Court. You have to give time. You see why they are known as Kapil Sibal, why he is known as Ramjet Malan. It is nothing easy. Because the moment they appear, it's a stalwart who is appearing in front of us, but they have done their homework. We have gone to sleep at 12 o'clock in the night. But these gentlemen, if you go, you see that the whole night he was studying himself. This is what it was. The moment you give yourself 100%, Almighty is always there to help you out. If you don't give your 100%, so basic thing is you have to read and read. The moment you do this, I can assure you, I might not, Mr. Mishra might not, or you might not be Ramjet Malan, but you will reach a certain extent in life where people will appreciate that this gentleman or this lady is very good in drafting, and she's also, or he is very good in making submissions. We are all aware, at least Mr. Mishra will know, because now our Lordship is in Supreme Court, Justice Indira Banerjee. Mishraji, I tell you, Justice Indira Banerjee, there was very few moments in High Court where she appeared. The moment she was elevated in High Court, everyone had the question, how could she become? She was having so less appearances. But what is the back history? See the other side of Justice Indira Banerjee. All the seniors in High Court at Calcutta at least could not make a pen scratch when she drafted. Beautiful drafting. Beautiful. Very short. Not that she is writing history, but to the point. So one part of her lordship, made her go to Supreme Court. And today she is a sitting judge of the Supreme Court. So these are the things which I would like to enlighten, and there are so many other things. One thing which I would like to say, Mr. Mishra has spoken about this contract review. It's very important. Why a review? We have to understand what is the meaning of review. Let us understand what is review. Today, suppose Sampurna, being a judge, is adjudicating a matter, and after Mishraji and I, being on the other side, argue the matter before Sampurna, and ultimately Sampurna adjudicates the matter and passes an order in favor of Mishraji. See, there are law says that I have a right of appeal because she's not the last court. If she's an High Court judge, I have the law. The law is very clear. I can prefer an appeal. But at the same time, Mishraji will also agree, and my learned friend, that I can ask for review. Whether it is High Court or Supreme Court, I can file a review application. So what is review? Basically, you are asking the judge to reconsider. If you are asking the judge to reconsider, my friends, then why not? Whatever I have drafted, it has to be reviewed by an expert. Today I might feel I am so overconfident that Imtiaz Ahmad has drafted his matter. I am the best. But the moment it is, given for a review or a checkup to Mishraji, he might find some mistakes. There might be some important points which are missed. So that is what review is. I hope I am clear. I am making you understand, the meaning which can hit at the point. So review is necessary. Otherwise, Mishraji was correct that if you don't review, there is 100% chances of litigation in the future. And in today's last quarter of the 21st century, I must tell you, we should only look for one point. Even the Supreme Court, the High Courts are trying their level best. What? To dispose of matters. To dispose of matters as much as they can. If you don't dispose of matters, then the people are running from pillars to post. There are so many incidents. Litigants went to the court, trial court, 30 years fighting in the court. The judgment came that he lost. He jumped from 8th floor, committed suicide. So he was thinking that what I was doing 30 years, I wasted my time. This could have been done in 2 years. So today, why I am telling this, we don't know. Even Mishraji doesn't know. I don't know whether these people who are listening to me, they can be future judges of a High Court. They can be future judges of a Supreme Court. You are the future. We will be all proud of you. You have to understand that. And why do we always say that the judges have to use the judicial mind? Once you're sitting in the chair as a judge, you have to apply your mind. And that is why contract is something, I think, which is one of the most, everyone will agree, important piece of evidence. And it has to be checked after you draft by an expert. Now let us go to section 45. Everyone knows Evidence Act. Experts' definitions are there. And in this expert, I think only a lawyer is expert. With these words, I am thanking once again to all of you. A very happy new year, and especially I must thank Mishraji for enlightening us today with his knowledge. Thank you, sir. These are my words.
Thank you so much, sir, for enlightening us and laying out beautifully the structure and the style of legal writing with respect of contract drafting. Thank you so much, sir. So there is a sir, if you would allow me to address a query to you. There is a question asked by a participant.
Yes.
Is there any particular format of contract?
Yes. It is a particular format of contract is that there are certain things which has to be there. Now, so far as that part is concerned, you must see that these are the parts which has to be there. When you are drafting a contract, force majeure, arbitration clause, indemnification, assignment, confidentiality, warrantize choices of law and forum selection. As Mr. Mishra ji has said, jurisdiction. Categorically he said, I remember, I was giving a very patient hearing to him. Then the time of the essence of clause, severability, and if any liquidated damages clause should be there. If these are not there, then it's a defective call, I think. And my learned friend can also add if they want to add something. It's a question to all of us, right?
Yes, definitely.
Chandraji, you can say something if you want to like to add.
I'll reserve my comments on that. You have adequately answered the question, and of course, I would only say that there's no rigid format, but there are distinct components of the contract, as you rightly mentioned, and one has to understand that there are certain essential elements of a contract which must be there in a well-drafted contract.
Right.
So there is
Now,
another
I'm
question.
waiting to hear you now. I would like to give you a patient hearing. Humera,
Yes, sir.
question part, let us lead to the last. After Mr. Chandra completes, all three of us jointly will be answering. Let us go to Mr. Chandra.
Okay. So moving ahead, I would like to introduce our third panelist for today, Dr. Maurya Vijay Chandra sir. He is the founder of Advocate Legal with over 23 years of experience as general legal practitioner with expertise in the sector of employment, public and private, intellectual property and public law, practicing commercial and corporate, international and national trade, arbitration and litigation. Sir will talk about the international aspects of contract drafting. With this, it's over to you, sir.
Thank you, Humaira. It's indeed a privilege for me to be amongst you. I can see that there are 73 participants, which means there are at least 70 people listening to us, which is a great pleasure. And I must at the outset begin by thanking the two co-organizers, Shivam Saha and Sampurna Saha. Both of you have been very, very sincere in getting us on board. And, it's always a little bit of a difficulty to commit to these kind of engagements, but the persuasion that you have demonstrated is great, and the organizational skills that you demonstrated, having the prior meetings and between the speakers and briefing us all properly, and the splendid poster that you brought out, they were really worth appreciating. Thank you, both of you, and thanks to the organizers, Legal Vidhi and Literary Art Clubs, and of course the college itself, Surendranath Law College, and I was very heartened to see or to learn that I will be addressing students who share their alma mater with Dr. Rajendra Prasad, the first president of the Republic of India. And indeed, I must also share that I have a Calcutta connection. I say Calcutta, not Kolkata, because at that point of time it was Calcutta. I started my education in Calcutta. It was the year 1979, I believe, and I used to live in Lake Gardens. I think it is one of the suburbs of Calcutta, near Prince Anwar Shah Road. And whenever there is a request from anybody in Kolkata, it evokes those childhood memory, and I'm always excited to be a part of that proposition. So, and I must also put on record my appreciation for both the speakers, especially Mr. Binodanand Mishra, who set the tone for today's webinar, and who also, incidentally, I think, referred my name to both of you, and Mr. Ahmed, who's done such a splendid job of taking Mr. Mishra's exposition to the next level. So that was great, Mr. Ahmed. And now I would also like to mention Humaira, who's been doing such a splendid job. Calcutta is a truly metropolitan city, and of course, unlike Dr. Rajendra Prasad, who was advised that be aware of these distractions in Kolkata, or Calcutta as it then was, my acquaintance with Calcutta, and my having visited Calcutta occasionally because I then grew up in Ranchi, which was very near to Calcutta, and close cultural connections. So that led to a situation that when I was doing my master's at the London School of Economics, the scholarship donors came for an interview, and they asked me as to how do you find London? Is it a change for you? Do you find something different? And later on, I thought I was a little bit uncharitable to them, but I was very to the point and candid to them, as I usually try to be. And I said, well, the city looks almost like Calcutta, so I didn't really find it any different from that. And they were just looking at me, staring at me, and then I realized that, oh God, they were fishing for something different. That it's so splendid, so new, such a great experience. And let me tell you, at that point of time, London, that was in 2002, London still had those roadmaster buses, as it's London Transport for London buses. So I almost felt that I'm in Calcutta with narrow streets, tall buildings, and those kind of buses. And you still had those strings that you pulled to indicate to the driver that you need to get down. So that's the beauty of Calcutta, and that's the wonder that I really have, and the appreciation for the city. It's truly a city of joy. Now, coming on to the topic of the day, and I must mention that the reference to what I would term as transferable skills by Mr. Ahmed is really great in the context of contract drafting. And it's not only the command over language, but also the understanding of the business itself, which is very, very important. And it's a transferable skill. And I would like to, mention that there was a time that in Patna, people would go for drafting of sale deeds, not to lawyers, but they would go to a katib, what is called a katib. And there was one katib, I forget his name, he's no more now, but he was the most popular. And it is not because he was equipped in the legal profession or he knew the law so much, but the sheer exposure he had to the number of transactions that he could really anticipate the risks in a particular set of title deeds that need to be conveyed. Now, as you know, sale deeds are deeds, which is another form of contracting. It's just that so the basic drafting skills required are the same. I'll elaborate it a little bit later in my presentation to you, but sale leads are also like any other contract where you mention all the things that, and it has all the components that Mr. Mishra was referring to earlier, and Mr. Ahmed as well. So now from sale lead, I must say that the contract drafting in the contemporary legal world has acquired a significance, and a special significance, after globalization and the increase in international trade, because trillions of worth of goods and services are being traded, and when there is a trade, there is a huge amount of documentation required. Now, all the documentation, all the transactions will not have the same amount of contracting involved in that. There would be some standard form contracts, there would be some big contracts, there would be some small contracts. Now, earlier this month, I had an intern, and he really was very excited about learning the law of contract and doing some drafting, and said, okay, I'm doing an arbitration, why don't you assist me in that? And then I briefed him on Actually, we used to brief our seniors, but these days, we also need to brief our juniors and interns. So the kind of the scenario of practice has changed. But I must also put on record that my senior at Ranchi, I practiced for a few years at Ranchi as well. Mr. Anup Kumar Mehta, he was a person who used to brief me, and I used to say he has spent so much time. I used to think actually that he spent so much time telling me all about the case, and he wanted me to argue. Why doesn't he argue it himself? And now, after 22 years, I realize that I have got the same attitude as well. I just ask my juniors, okay, this is the matter, this is what you have to do, just go and do it. But anyway, coming back to the contemporary importance of contract, and so when I asked my intern that, no, go through this, and of course, perhaps it was a tall order for him, but I asked him to read a contract, and the contract was about 116 pages, just the bare contract, not the schedules and annexures. And he went through it, and then after the 2 days later, he comes to me and says, "Sir, I don't understand most of it." And I said, "Yeah, good, but that is your job, to understand what it is. You can't say this to a client." And he says, "Sir, maybe it's too difficult. Can I have a smaller contract?" Then I give a contract manufacturing contract to him. And that is about 46 pages, excluding the schedules and annexures. And I'm yet to hear from him, but I expect that he will come to me with a similar answer. Now, what is important in this, why I mention this, is that contracts will be of all sizes. A 2-page, 1-page warranty contract, 4, 5, 6 pages non-disclosure agreement, or hundreds contracts running into hundreds of pages, typically infrastructure contracts, where you have legal teams poring over every word of the contract, and a team of 5 or 6 people just studying the same contract and identifying risks. And this will typically happen in large infrastructure projects like IRCON, like airport authorities, the national highways authorities, those kind of construction contracts. So, first of all, when we are talking about contract drafting, we have to understand where is our niche, what skills, what kind of contract we want to draft, where do we want to focus. You, as a practitioner, should not aim to do either of the two. I must tell you, and I'm reminded of a story that my dad used to say, and I don't know whether it is true or not, but I take it as true. He said once a question was put to Einstein in that there are 2 cats. One is a small one is a big one, and they have to pass through a wall. How many holes do you want to drill? And he said 2, one for the small and one for the big. So typically this happens with contracts as well, and in my initial years I really experienced with myself, I must tell you that at times I would import a lot of complicated clauses from big elaborate contracts into smaller transactions. Now, a contract for warranty, for a service warranty of an air conditioner does not merit so many complicated clauses. A 2 pages contract is good enough. Otherwise, neither the dealer will understand it nor the consumer will understand it. So one has to understand that the right size of the contract is very important, and you have to identify as a draftsman as to whether you are capable to draft it in that manner. Do you have the scalability to do that? And there's no harm in admitting to yourself that I do not have the scalability to do that. And typically, if you go to a big chamber, to a senior, he would say that I would not draft this, my junior will do it. And it's not because he's being egoistic that this is too small a contract for me to draft, but because he recognizes that he has moved on from this, and it will first, it will not be worth his time, and secondly, it will also perhaps not, he will not be able to do justice to the simplicity that that particular transaction requires. Now, I will further elaborate on the objectives of contract drafting. From where I see it, I do not know whether others would agree or not. From where I see it, contracts are basically documents that identify risks and allocate those risks among the parties to the contract. So what happens if it is a contract for say outsourcing? Or maybe a joint venture. Let's take a simple contract. What will happen? It will the contract will identify that there is the risk capital to be invested. Now, how much of that risk capital is to be invested by whom? That is going to be allocated in that contract. Then there might be a risk of business failure. Now, who would carry how much of that risk? So this is done through the implements of debt financing or equity financing. So far as debt financing is concerned, that will take the financial risk of financial capital allocation, and the equity financing takes the risk of business failure. Then in so many, data protection is another example. So, for example, as I was mentioning, in an outsourcing contract, what will happen in an outsourcing contract? Data will flow from a foreign jurisdiction to Indian jurisdiction. I'm taking specific examples of an Indian outsourcing contract. Now, if that data flows across borders, there are certain statutory obligations that the outsourcer or the person in a foreign country will need to comply with. Now, those regulations are not necessarily applicable. Now, we know that until very recently, we didn't even have a data protection framework, let alone anything else, not even a data protection format. And the difference between the legal systems will always be there. So what happens if there are certain obligations which are placed upon the person in the foreign jurisdiction? He has outsourced it. He has to ensure that those obligations are met by the person to whom the work is outsourced. And how does he do that? Contract is the first and foremost tool to achieve that outcome. So it's about identifying risks and allocating those risks to in this instrument. And most of you would have heard of due diligence. Now, if you go to due diligence process, again, it's the same thing. Identifying risks and allocating those risks. And how do you do it? You do it through conditions through warranties, through representations, and through indemnities. So this is the widespread. Given the timeline, I might not be able to delve into greater detail. And then, as Mr. Mishra and Mr. Ahmed rightly pointed out, enforceability is one of the key aspects. Certainty, as they pointed out, is one of another key aspects. And here I would like to mention the two points that the speakers respectively took was clear and ambiguous drafting. Now, this is very, very important, clear and ambiguous drafting. And we have to understand as lawyers that ambiguity does not necessarily mean that you use complicated phrases. In fact, internationally and in international contracts, there is a great movement towards plain English. Now, we have a fancy for writing thereof, whereof, whatsoever, all these things. The world is moving away from this. So, if you use plain language, plain English, that is appreciated in international contracts. Of course, if you have a complicated big contract, these things will not be avoided. But you should try to avoid it as much as possible. And the second thing was strengthening the command over language. That is what Mr. Ahmed said. Now, strengthening the command over language is something that cannot be overemphasized. It has to be there. You must have a very, very good understanding of the language, not language that you have read, but as language that will be read. So you have to always keep in mind that your contract is going to be read, and although, as the two speakers said, your job is to ensure that there is no litigation is avoided, you have to anticipate that litigation is going to come. So you avoid litigation, but at the same time you anticipate it as well. So that is something that one has to be very, very careful about while drafting a contract. Now, after that, I would mention that a very, very, very simple tool is while you are reviewing or even while you are drafting, you have to take care of internal consistencies in a document. So when you are referring to clauses, you don't say at one place you don't refer to them as articles, and the other place you don't refer to them as a clause or a subclause. So that is the very elementary example of internal consistency. But sometimes what happens is that we tend to refer to the same concept in different terms. Now, when you ambiguity in interpretation, so you have to be very mindful that internal consistency in a document is very, very important. Well, I had certain examples, but I think we are running out of time, so I'll skip that. But can we have a very quick survey out of these 67 people who are still with us? Can we have a quick survey on examples of international contracts? Because my address is limited to international contracts and the aspects of drafting as applicable to international contracts. Can we have a quick survey, please? Can you please write in your chat box the examples of contracts with an international dimension, like one I mentioned, outsourcing contracts. What other scenarios do you see where you will have international contracts? Come on, please.
So just one thing, I believe we have enough time right now, sir. It's 6:37.
So let people respond to this.
Sure, sir.
Well, I appreciate, Sampurna, you're telling me that, but I was telling in the context that I have just covered about 2 points out of the 10 that I want to cover. So,
allow him to continue. It's quite important. This is very important.
Yes,
Allow Mr. Chandra to continue. This is very important what he is talking about.
So while you list the examples of international contract, I would like to outline some of the issues that arise in contracts with international dimensions. Now, typically, if you have heard of boilerplate clauses, do we have any meaning of any means of ascertaining people raising hands or anything of that sort here? No, we don't. Anyway, so then I'll just continue. So in boilerplate clauses, you will find the certain clauses which are necessarily there. The choice of law, choice of forum, enforcement of decrees, urgent injunctions related clauses. Then you have conflict of law, mention of conflict of laws, and costs of litigation. I mean, these are certain clauses in a contract which typically we do not even pay attention to. And here I am reminded of my experience as a what I noticed there was that most of the topics that I would miss in the end of the semester was what I would use the most when I am practicing. So remedies was one topic which was last, and which we typically said, okay, no time for it, read it, if you have any doubt, we will clear it. But remedies is what we earn our bread and butter of. So similarly, these are tail end provisions of a contract, but very, very important in the international context. So I will just repeat that some of the issues that one needs to consider and deeply think about while drafting contracts with an international dimension: choice of law, choice of forum, urgent injunctions, conflict of laws, litigation costs, and enforcement of decrees arising out of any litigation out of the contract. Now, when I say choice of law, it's very, very elementary. You have a contract between a person in England and a person in India. The two legal systems, though, have a common heritage, but still they are distinct and dissimilar in many respects. So, which set of legal principles will actually be applied when you are interpreting the contract, when you are resolving a dispute, or even when you are discharging the obligation? That is very important. And in the contract itself, usually there will be a clause that which law will be the governing law, which means if a party has chosen that the governing law is going to be the law of England, the law of England will be the governing law. But if the parties have chosen it will be in law of India, it will be the law of India. Here, what we need to understand is that choice of law is not necessarily and always the choice of the contracting parties. Sometimes the statutes will force you to choose a particular law. For example, when you are entering into a contract in relation to a property in India, it will be ill-advised for you to choose the law of England as the governing law. And even if you chose that, ultimately when it would come to the courts for resolving of a dispute, the law of the place where the property is situated will be applied. Then you have choice of forum. Now, choice of law is the choice of set of legal principles. Choice of forum is the choice where you will resolve your disputes. So you could choose a forum of India where your choice of law could be of England. So an arbitration in India with the governing law as the English law. Typically now in arbitration you have Singapore as or Dubai as the place of arbitration, the what is called the lex loci, where the procedural law of that particular place will apply, but the substantive law, perhaps this distinction will be better appreciated by all of you, the substantive law of a particular country applies. Then you have enforcement related issues, enforcement of decrees, and there are certain grounds on which enforcements can be opposed in various jurisdictions. And in a contract, when you choose, when you choose to draft contracts, you choose both the lex, the governing law as well as the forum. You keep this in mind, that when there is a decree, where will it be enforced? For example, if you see inevitably any decree that you will get has to be enforced in India, you will probably want to have the forum as the Indian forum, so that the enforceability is easy and automatic. But at the same time, if you if you choose the law of England as the forum for resolving dispute, then for example in arbitration, what will happen? The award will have to be then recognized in India and then enforced. So this is an issue that needs consideration and thinking, and also some study as to what are the contemporary trends before you finally draft a contract. Then you have injunctions. For example, you have chosen the law of Nigeria as the governing law in a contract between an English party and a Nigerian party, and the Nigerian party is the one that is breaching. will you be able to get an injunction in England? That is a question that you will have to consider. Especially this issue arises in non-disclosure agreements. In non-disclosure agreements, typically your remedy is injunction. Now, if the person who you want injunction against is not located in that jurisdiction, what is the use of your injunction? Because these are typically ad interim injunctions. Today you go to the court and you want injunction for tomorrow and to be enforced. Now, if the party is in a different jurisdiction, again you have a question of enforcement of foreign awards or foreign decrees. So the injunction will have an enforcement issue. Of course, at the time of litigation, you sensibly choose where you file injunctions, and even if you have chosen a different forum, you will try and get the injunction from a local court where the person to be injuncted is present. But while drafting a contract, you also see where does your remedy lie. Who would you actually? Where would the person being injuncted be located when you are enforcing the injunctions? Then you have the principles of conflict of law. This is given that it's a very kind of a dispersed and diverse crowd. I would rather skip this because it's a very technical subject. And last, as I said, litigation costs. Litigation costs are typically the American principle is winner takes all. For us, it is the court decides who to grant, and in a contract, you can settle as to what will be the ultimate principle on which this will be decided. Now, if I can come back to the question, do we have people responding to my earlier request on the examples of international contract?
Yes, sir. We have got a couple of messages, sir.
Okay. So, kindly read out the name as well as the examples that they have given.
Sir, Upper Software has written international business contract.
Okay, good. And
Anushati Banerjee has written international strategic alliance contract. And another one we have from Kripa Kami. She's written international sales contract.
Good.
Also, another one we have from Anil Ghoshal. Agreeing to the terms and the conditions of social media companies.
Okay, good.
Also, we have from Megha Ghosh, agency contract.
Good. So, 5 responses.
Yes.
That's great. So all 5 of you, I don't know if you are law students or not, but if you are law students, you are welcome to intern with me if you ever need an internship. So I would also like to add, apart from this one important thing, and I mentioned it earlier, joint venture and shareholders agreement. So joint venture contracts are very important contracts with the international dimensions, and shareholders agreements. And shareholders agreement are important in the context of multi-jurisdiction businesses that we have today, because different jurisdictions will allow certain things and not allow certain things, whereas businessmen, global businesses have their own ideas and understandings about the terms on which they want to do business. So typically they structure it. They structure it in a way that although the local businesses will have their own set of rules, ultimately at the level of the shareholders, they will have the desired set of rules that they want to implement. So again, this is very very technical, and I'll not go into any further detail on that. I'll now come back to what I was referring. And when you anticipate litigation, you have to keep in mind the principles that will be required, the principles that will be taken into account or resorted to when the contract is being interpreted. And whenever you are drafting a clause, you must think as to what principle will be applicable when this clause is being interpreted. Now, you have to know the legal risks that you are allocating in the contract. And for this, when I say legal risks, it's the regulatory, statutory prohibitions and enablements. For example, you cannot have a foreign direct investment contract with 100% ownership in the defense sector. You must know this, that this is a legal risk. So that you can advise your client that, look, this is not possible, this is not enforceable. Sometimes, in some jurisdictions, I was acting in an instruction in Brazil, where you are not allowed to assign your mining licenses. So if you can't assign your mining licenses, then nobody with a mining license can come to you and say, let's do a joint venture, or I want to sell this mine to you. If you have to buy a mine in Brazil, either you have to have your own entity and get the license in that entity's name, or if you want to buy it out of the person who has already acquired the license, you will have to look at alternate structures. You cannot have a simple assignment. So know your legal risks so that you can address them. Then and I mentioned earlier, the due diligence process is all about that. Then you also need to know about litigation tactics. When you anticipate litigation, you also play it out, that what will happen, this party will do this, and then whether I will have the chance to respond or not. You can have a perfectly well-drafted contract, and still the other side might be able to get the better of you because they are good in their tactics. So, for example, well, it's not an international contract scenario, but if it is a contract, it was an annual contract for purchase of certain goods out of a factory, and there was a dispute over the rates, and there was some ambiguity in the contract, and all that the other side did was to file a suit for injunction, and he got an ad interim injunction, carried on with the contract till the end of the tenure, and then the suit was infructuous. So you have to understand how the other party might be able to defeat your cause. And when you know the legal risks, you know that certain things cannot be done, then what you do? What is called structuring. So, for example, external commercial borrowing is very onerous. You have to take RBI permission before external commercial borrowings come into the country, and you have to justify those borrowings so much. But FDI is possible. So, what you do? You say, okay, I bring in FDI, and then I give the debt within India to various parties. So this is one of the examples of structuring. Okay, it's 6:53. How many more minutes do I have? Myra?
So you may take some few more minutes, and then we'll be moving in the question answer section.
Okay, to stop you. Let us stop.
Now, I'll touch upon the next 3 points, 3 or 4 points very briefly. What you need to understand as a draft person of a contract is the importance of a solution-oriented approach. Now, businesses do not want, they typically see lawyers as hindrances. So, one of the reasons they do not come to you is that you always point out risks. If you do this is the problem. If you do that is the problem. Businesses want solutions. So, as a contract lawyer, you have to be solution-oriented. So, as I just mentioned, if there is a problem in ECB, you have to give them a solution that, look, enter into an FDI structure. So, similarly, in all respects, you have that. Your job is not to take the management call. You have to understand that the management will take the management call. All you have to do is to tell them that, look, these are the risks. Enter into this contract with your open eyes. And there is an example that I typically use. There are people who would play with snakes, who would have their tongue bit by snakes. So it doesn't mean that you can get away with that or you can do that. But if you think you can get away with that, okay, why not? Go ahead. There are some people who can carry that. So do that. So you have to point, and for that, most of us would know what the business considerations are. But our job is to just tell them that these are the business risks. If you want to take them, we will do the best to protect you in these circumstances. Don't come back to us. But how do you ensure that? That you ensure through what is called commercially as a term sheet. So you give them that, look, these are the terms of the contract which you have instructed me. I might have advised you against one or two of them, but still you want to do it, I'll do it. Typically what happens, it's not very popular here, but in foreign jurisdictions, especially in the developed countries, you will see that whenever there is a real estate deal, the deal is never through without a lawyer. But in the deal, you will have this term sheet, price so and so. The other terms will be listed in that major terms, and that will be given to a lawyer who will then do his due diligence and all that, and then who point out that this is the final contract. So what you do is get the client to sign off to a term sheet, so that when they come back to you, oh, this happened, that happened, you didn't tell me that, you have that to fall back on. But more than fall back, what is important is that this ensures that the person taking the business decision knows what he is doing. Your job to implement that business decision. Most of us mistake the roles which you in your later careers should avoid. Then, as I was earlier referring about various types of clauses, in international scenarios, certain clauses become very important, which in domestic contracts we don't pay much attention on. And as one of, I'll just list out like representations and warranties become very important. And if it is representation about foreign law, the state of foreign law, it becomes all the more important, because foreign law in the Indian context are treated as facts, and representation of facts have a different consequence under the Contract Act. Then conditions subsequent and conditions precedent become very important, and then this dispute resolution and indemnity clauses also become very important. Now, the next thing I would like to point out is that internationally we are moving towards what is called a framework contracting. So the typical contracts that we have seen is you start listing consideration, and then all the various representations, warranties, conditions, and go ahead on that. Framework contracting is something like the statutes that you have. Bare bones of the contract, for example, a contract of service. Contract of service will have, okay, this is the vendor, this is the employer, then this is these are the broad terms, and then they will say that the scope of work as specified in schedule. Consideration as to how much price will be paid, rates written there, subject to revision based on the following principles. So this is called framework contracting, and all the contracts that I was referring to earlier, 46 pages contract without the schedule and annexures, the 126 page contract without the schedule and annexures, all these are framework contracting, and this is slightly counterintuitive, but this is informed by the principle that you do not need to negotiate the legal terms between the legal relationship between the parties every time you want to place an order. That can be done once, and then later it is an iterative and repeatable process. This brings down the legal costs of corporations, and that is why this is more in vogue. And secondly, what it allows you to do is to work with a vendor who you know you have to work with. So whether you have a dispute or not, you will still contractor abandon the highway project right in the middle of a contract. And Well, I think my time has run out. I know Humaira and everybody is being very polite. So thank you so much for this opportunity to connect. It's been wonderful. And I'm happy to take any questions if there is still time for that. And I'll be happy to connect. And I'm sure if you need my contact details, the organizers will be able to share with you my contact details. Thank you.
Thank you so much, sir. Thank you so much, sir, for sharing such important insights about international aspects of contract drafting. Thank you so much, sir. So the house is now open for the question answers. Also, we have received some questions. So to all the three speakers. So Maurya, sir, there is a question for you. If you please allow me to address it to you.
Please.
Yes, sir. So the question is, can the form of government in a country which is a party to a corporate contract influence the terms of the contract?
Can a
So I'll repeat the question. Can the form of government in a country
form of government
in a country?
Yeah, of course, if it is relevant for the purposes of contracting, yes, but in commercial terms, no. And there was a big research project on the rule of law and contracting and democracy and contracting. In fact, my own PhD supervisor, it was her project and it's an empirical research, and she came to the conclusion that unlike what much of World Bank and ADB advise, the form of government, they care about their business and the premium that they get on that. And rule of law is a consideration, but not a huge consideration. I hope
Thank you so much, sir. Thank you, sir, for the question. We have another question. It is an open question, so any of the speakers can actually answer it. The question is about the essential elements of business contract.
Business contract?
Yes, sir, the essential elements of business contract.
A business contract has three distinctive stages. One is preparation, the other one is perfection, and the last one is consummation, subject to correction. I will be corrected if I am wrong, right? Any sort of contract. But so far as business contracts are concerned, so you see what Mr. Chandra has discussed. I was listening to him. The most important nowadays, the problems which are arising, I think he will be agreeing to what I am saying, is regarding those export and import contracts. These are the contracts which, there are serious problems now which are landing up. And internationally, if you see that those people who are involved in this business of export and import, there are a lot of categories to it, that what are the goods which you are sending. Now, naturally, what Mr. Chandra has answered just a few moments back. See, these type of things, the jurisdiction might come, the cause of action might come into play, and even, you see, because it is the export and import is within countries, cross borders, the government might have a role in it. That is what I feel. Because the statutory policies will also come into play, apart from work. Because the moment it is disputed, the only way for a person is litigation, either by approaching the court or an arbitration process.
Okay, sir. Thank you so much, sir, for the answer. We have some other questions.
Yes, please. Carry on, Humaira, we are ready. All three of us.
A participant has asked, what is the best way to learn contract drafting, or where we can learn or get a specialization in it?
Best way to learn contract drafting is first your basics. I told you, read. This is the basic mantra. The moment you start reading, then you will get interest in, what in your subject itself. Apart from contract, first read storybooks. A lot of reading procedure is required. The moment you do this, now it will be easier for you to draft a contract, because the only thing which is required, I said, enforceable because it has to be enforceable by law. Whatever you are drafting in your contract, it has to be in relation to the law of the land.
Okay.
I would like to add on that, Mr. Ahmed. So there are certain master classes that are conducted, but in a very specialized, areas like VC, venture capital investment, and all that. But they are for really advanced professionals, not for students. One of the reasons is that you need to know the business before you do that. The second thing is that there are certain online courses which I have also come across where you can learn that. But as Mr. Ahmed was saying, that reading is very important. And the second thing is, as I was emphasizing earlier, that you need to first find your niche, where you want to be, what you want to do, and then based on that you can you can figure out where to learn. I mean, if you have a legal aid society or anything of that sort, I can offer to do a one-day session for contract drafting. But essentially, you need to practice. That is what you need to have a senior under whom you will learn and apply yourself to the facts and circumstances of cases. And that is why I said that if there is a legal aid clinic or something of that sort, there you can seek instructions. And my library, my first port of call used to be the book vendor in the High Court. When I was practicing in Patna High Court, it was the Preetham Law House, and then later on there have been others. So when you go there, they have a good collection of 4 or 5 standard contract drafting books. You can browse them and look at it. I think there's one by Mitra as well, I think. And
Yes, but we and our
I think one is by Rafat Alam, Honorable Judge of the High Court.
Yeah.
Retired.
So you start with D'Souza and then you go on with so many others who have followed suit.
And when you talk of elements of contract, then you should talk of an offer, acceptance of that offer, consideration. Then contract must satisfy the parties, and those parties must possess the legal capacity to enter into the agreement. The subject matter of the contract must be one that is legal, and then there must be mutual agreement between the parties. Parties must have a mutual understanding of the rights and duties. These are the essential elements.
Okay, sir. Thank you, sir. Thank you, Mishra, sir. So we have a question for Imtiaz Ahmed, sir.
Yes.
In case of interstate contracts, is there any specific law governing the contract?
So far as interstate is concerned, no. Because I tell you, we are all Indians first. Now at this last quarter of 21st century, we are facing a bad experience. If someone comes from the other state in West Bengal, or someone like me goes to Patna, I might be called as an outsider. That is not done. I am a citizen of India. I am proud to. Law is same, Humera. Please tell all my friends. The law applicable. You see the first section of every act except Jammu and Kashmir. Section 1, any act which you read, IPC, CRPC, they say it is all over India, through India, as a citizen. But why they say Jammu and Kashmir? I can give you an example. I had the privilege of attending one matter in Jammu. You know, the IPC which we say in West Bengal or Delhi or Bombay, they say RPC. But I tell you, everything is same. Everything is same.
And Mr. Ahmed, now even that has been done away with.
Yes. He is correct. Mr. Chandra is correct. So, the basic thing it is no. The answer is no. Everything is same. But only thing it might appear, because I will have the privilege of first time appearing before Lakhimpur Kheri. Why application 482 CRPC has not been considered by the Allahabad Lucknow bench, because they have referred the matter that I should go to the trial court under 239. 482 was not allowed. So they say that you procedurally go to the trial court and file a 239 application, that is discharge. So most probably I'll be going there. I don't know, my colleagues there are saying that the papers which I've sent, first of all they say that it is huge, इतना सुनता नहीं है उधर, और आप थोड़ा अपना हिंदी ठीक करके आइएगा, ज़्यादा इंग्लिश मत बोलिएगा. So this might be a problem, but everything is safe.
Okay, sir. Thank you, sir. Thank you for answering that question. So, we have a question for Mishra, sir.
Yes.
Sir, could I please address the question to you?
Yes, why not?
Yes, sir. So, when we state the terms and conditions in a draft, how do we balance those so that both the parties are satisfied?
So it depends upon what they agreed upon. You just have to write it down. You just have to record it, and you have to see that the interest of your client is not jeopardized. That's all.
Okay, sir.
That count has to be given effect to.
Mishra sir,
You have to understand the intention of the parties very clearly, and then you have to write it down as close to their wish as possible.
Mishra sir, I'd just like to add one thing.
Yeah.
If they don't agree, right?
There is no agreement.
There is no agreement. Simple, simplicity.
Alright. So, if any of the participant has any questions for all the three panelists, please address it in the call messages of the Google Meet and the live chats of YouTube. We'll be taking the questions.
Umaira, last but not the least, do you know that even our marriages are contract? Do you know this?
Definitely, yes.
If in my marriage my wife would have said Kabul nahi hai, then I would have seen stars in my, I would have been shocked. So it's always an offer and acceptance, as Mishra ji said. If Kabul mein offer nahi aata na, to then mera shauq nahi hai.
A social contract, definitely, sir.
So contract is not confined to commercial world only.
Yes.
So there is a question which is open to all the three of you. So anyone can answer. The question is that please explain about the trusteeship contracts. How do they function?
Trusteeship of a contract. I think Chandra will be in a position to enlighten all of that.
Trusteeship contract. Can you have the person elaborate on the question a little bit more? Are they looking at the contracts that trustees enter into with the trusts for discharging dividends?
No, trusteeship contract. You can write a deed of trust. Where the trust deed, where the it's a misnomer to say that trusteeship contract. Deed of trust,
so the question
you can.
is about how do they function? How do the trusteeship contracts function?
So, can we have the person elaborate on the question a little bit more, so that we can pinpoint the answer, because this is slightly.
I will explain, Mr. Chandra. What they are trying to ask is that in a contract, we can always make a trust deed, as Mr. Mishra said. It is in relation to a property where the person who was in his lifetime has dedicated the property to Almighty God. So in Hindu religion, if I'm not wrong, it comes as devoted property. And if a Muslim, while in his lifetime dedicates a property, it becomes a walk of tree. It becomes a walk of trust, which becomes a contract. So according to that, during his lifetime, his desire was that these are the 5 mutawalis which are as per the Walk of Act, and they are going to look after my property, and the outcome which comes, it will be spent for the poor and needy people of the society. This is what they are trying to mean.
Okay, because in the commercial world, this is also executed. What happens is when you have international financing agreements, and especially when it goes through multiple jurisdictions, you cannot be a director on the company at various places, and at some places, internationally you constitute a trust, and this happens especially when you have international contracts where you take money from one jurisdiction to the other and tax havens. So there you have trustees appointed within those trusts, as well as in companies. companies. So how are they implemented? This is something that I thought maybe they are referring to that. So that's why I asked to clarify.
So shall I answer them? Shall I answer them?
Yes, please.
See, Humaira, the question is whether how does the trustee comes to a point? It can. I said that any property during the lifetime of a Hindu by birth, he wants to dedicate it after his death. Suppose he does not have any legal heirs. So a trustee that Mishra is correct. A trustee can be, executed, which is basically a contract. Because the moment he is leaving the world, there are some people whose name are there in the deed who are supposed to look after the property and take care of it. And when the outcomes come through in a way of money, it has to be spent for the poor and needy people. It is likewise same in a walk of property. There are thousands of walk of property, as Mr. Chandra was saying, that is very happy. He is very happy when he comes to Kolkata. Once he had the opportunity of traveling in a tram. But I must tell you, Mr. Chandra, that 80% of the property which are now being owned by us, everything was all, now they were all walk of property. And everything, or most of the people in the minority, they have been deprived from these properties, in spite of walk of trustees.
So, sir, we have a last question for today's webinar. The question says, does the government policy provide serves as a hindrance to the contracts?
Sorry, can you repeat that? The government policy?
So, serves as a hindrance to the contracts.
Well, of course, if they are directly on the subject matter, there will be a hindrance to the contract. Depends on what you understand by hindrance again. But
if you're trying to hire hitman, the law will prevent you from doing that.
Yes, and especially, but they are referring to policies. So, policies, public policy of law or simple policies. I take it as simple policy, and government policies do inform contracts. So, when you are identifying the risks, you look at the policies. Although they are not binding documents, but they are sufficient indicators of how the government sees a particular subject matter or how it wishes to regulate them, even though not incorporated in strict rules, statutory rules. And policies are subject to change. But yes, you do look at them, and whether they are hindrances or whether they are an aid in your business purpose, that depends on what business you are in.
Instead of creating hindrance, the law provides mechanism for enforcement of contracts.
Yes,
of course.
Specifically reflect and performance of contracts.
Okay, sir. Thank you, sir. Thank you for the answer. So we'll be taking this question as the last question. So the participants are requested not to question any further. So the last question that I would be addressing to the panelists is if after a contract is made, a law conflicting the contract is made, will that contract turn void?
The severity clause will come into play. It could be, if otherwise, if there is no severity clause, it would, to that extent, it would be repugnant.
Okay, sir. Thank you so much, sir. So,
it's been an absolute pleasure answering the contract.
Thank you, Dr. Moore, for giving such a nice and informative.
Thanks a lot, Mr. Chandra.
It's a pleasure. Thanks to you both.
Sir, I have a question to, may I ask?
The gelatin has fell.
You have the privilege to ask me questions even after this session.
Yes, sir.
Okay, but we'll give you this. Probably you were waiting.
Yes, we all are allowing you.
Okay, so thank you, sir. Sir, our tickets of lottery conducted by the government enforceable by law. Since we know that lotteries are weathering agreements, but the lotteries that are conducted by the government, are they enforceable by law?
Mr. Saha, are your question relates to contract drafting?
No, sir, but I know I think guidelines by the government in each and every state. If you are not following that, you can understand, Mr. Shah, what will happen to you. Because you remember, maybe 9 to 10 years back, this Lotto, you know, Lotto.
Yes, sir. Yes, sir.
People, most of them, you know, from the very poor section of the society, they were involved in these Lotto, which were completely illegal, which was not sanctioned by the government, right? So most of the owners now, till date I know, they have not got paid. So this is your answer.
Yes, sir. Thank you, sir.
Wonderful evening. We will cherish the memory of this evening for a long time to come. Thank you, Sampurna again, and Shah.
Sir, so we will just wait just after the end note, just after I deliver the end note, you may leave, sir.
Okay, no, I'm not in a hurry to leave.
Vote of thanks.
The webinar?
Vote of thanks.
Yes, sir, vote of thanks. So the webinar was very informative. We all enjoyed it. It was very interactive, and all the students, as students, we got to know quite new things today. And we are very grateful to all these three panelists for enlightening us with such important topics. So with this, we come to the end of the webinar. I thank the organizers for giving me the opportunity to moderate the webinar. And thank you, Sampurna and Shivamda, for your support and your guidance. I offer my heartfelt gratitude to all the three panelists, Advocate Binodanand Mishra sir, Advocate Imtiaz Ahmed sir, and Dr. Maurya Vijay Chandra sir. Thank you. Now I would humbly request the organizers to please take over.
Thank you. Thanks a lot.
Thank you, sir.
Thank you, sir.
And there has been a request for contact details, so I put in mine here in the chat box. Probably Mr. Mishra and Mr. Ahmed could also put it in there, and if you could.
Why certificates to us also? They would be issuing certificates to us also.
Yes, sir. I was.
That they could have done.
We have higher level best. Next time when we come, look forward to that.
For sure, sir. For sure.
Thank you.
I'll take over from here for Humara. Thank you, Humara, for moderating amazingly. Thank you for your glorifying spirit and taking this event with utmost spirit and zeal. As we come to the end of the event, I, Sampurna Shah, along with my co-in-charge Shivam Shah, on behalf of the Literary Arts Club, convey our sincere gratitude to our revered prominent panelists for the day. We are extremely privileged that in spite of their busy schedule, our esteemed panelists managed to make out time and enlighten us with their valuable knowledge and experience. Thank you, Binodanand sir, Imtiaz sir, and Maurya sir, for giving us your valuable time. Under the aegis of our prominent panelists, we have managed to successfully deliver learning experiences and outcomes to all the students who have joined in with us. The session was indeed very informative, and we hope you found this of use also. With this, I would also like to extend my thanks to the supporting team and the members of our academic society. I would just like to confirm for again if we have the members of academic society over here. Do we have our chairperson here, Shivamda?
Sorry, Sampurna, he's busy and he could not join.
Alright, do we have our Secretary General here?
No, we don't actually.
Alright, so I would continue.
He was with us in the beginning, but he somehow left.
Yeah, I understand. So even though they're not with us, their support has constantly been with us. We would like to extend our thanks to the chairperson, Mr. Shivashish Banerjee, without whose motivation and encouragement, none of this would have been possible. Our vice chairperson, Mr. Ramannath Ansari, and our convener, Ms. Shanaz Mezabi, for their constant support and encouragement. We would also like to extend our thankfulness to the Secretary General, Mr. Shojadeep Ghosh, who has been a constant support, a friend, a mentor, and a guide at all times. Last but not the least, I would extend our sincere gratitude and appreciation to the supporting teams for making this event possible. Ms. Humara Solanki, our moderator, Ms. Devina Pal, Shubhajit Shah, our PR team, Anantika Singh, Shrijita Singh for monitoring, Mahashwata Sarkar, MBS Semran, Ayan Vamik, Kripa Kami, Sujata Singh Roy, our promotion team. Special thanks to Arun for making this live stream possible. Our graphics team, Mayuk Banerjee, Rivanjun Paul, Samrat Pan, for handing over the most remarkable posters. Lastly, a big thanks to the entire family of the Academic Society of Surendranath Law College. We appreciate your constant support and devotion. Also, last but not the least, this session was indeed a very informative one. We hope you found this of use. Keep in touch and thank you for giving us this